This morning, it appeared Ontario's plan to slash the size of Toronto City Council had been thwarted. A judge ruled it was unconstitutional given the city is in the middle of an election. But Premier Doug Ford emerged to say, not so fast. This afternoon, Ford announced his government is invoking the notwithstanding clause to override that ruling, a tool that has never been used in the province's history. Can he really do that? University of Ottawa law professor Errol Mendes is here to help us break it all down. Hi, Professor Mendes. Nice to see you again.
Nice to see you too.
Okay, we're going to start with the Premier's announcement, and then we'll go through a long reality check.
Sure.
Let's take a listen.
And I have notified the Lieutenant Governor our intention to bring back the legislature back this week. Our first order of business will be to reintroduce the Better Local Government Act, and with it, invoke Section 33 of the Constitution.
Let's start right there. What is Section 33? What is the notwithstanding clause?
Well, it was designed as a way to get the Charter over the objection of some of the premiers when we repatriated the Constitution and the Charter in 1982. Now, it was designed essentially to save the entire repatriation and the Charter. So what it does, it gives those in Parliament or in the legislature to override the decision of the court for 5 years. It has to be renewed. But I would caution against using it because it is a strike against the entire Charter, because it is the first of its kind in the history of Ontario. The Ontario representatives who were part of the Charter negotiations were very, very much against it. And so I think it goes against the grain even of the type of political views on the Charter as a whole, because once you start using it, it could then be used over and over again. And my view is, in this case, there's no need to use it, because all that the court did was to say, if you had given more time, there wouldn't be any problem with this action. So my caution is, and my plea is to say, please don't, because you're attacking the entire Charter if you do this.
Let's say your pleas go unheard. What is the actual logistics of using it? And can the Premier do this?
Yes, he can. I mean, he can basically say, despite the ruling, I am overriding it, and I'm going to bring in the legislation now. I should caution, though, because part of the judgment, which no one seems to have noticed, is that the judge was actually saying, I actually have not addressed another set of arguments on what's called the unwritten principles part of the Constitution, which, if he does override it, there is nothing to stop the same lawyers going back to court and said, okay, he's overridden that. Now let's go on the other areas which he did not comment on. So, I mean, this again could be used to stop any further use of the extension to the 25 instead of the 47 wards. So my caution is that this could bring a very, very serious situation in Ontario if he went ahead and used it.
But he does sound like he has plans to do it. Is there, I mean, how does that work? So he'll bring back the legislature, and then do they have to vote on using it?
Yes, absolutely. I mean, he would pass the legislation saying, despite the ruling, I'm overriding the Charter, and for 5 years, he has to say for 5 years, etc. But again, I don't think he realizes that the same lawyers could go back to court and argue again on the basis of the other issues which the judge did not address. And again, there could be a judgment there. Do we really want this when the court is clearly saying, if you gave more time for this reorganization to happen, there would be no problems whatsoever? And that's why it is a bigger attack on the Charter if he goes ahead with it, given that the court is already saying there wouldn't be any problems with this if you had given them more time.
So let's get into what the court is saying. Well, first we'll take a listen to what the Premier how the Premier characterized this decision.
Virtually every single legal expert agreed that this law was completely constitutional and within the legal power of the province to enact.
Were you surprised by the court's decision?
I was surprised by part of it, especially where he's basically saying that another part of the Charter has to be read in connection with Section 2B, which is the freedom of expression one, giving voters, if you like, a form of freedom of expression based on Section 2B.
Yeah, can I just get you to explain that really, like in layman's terms?
Well, in layman's
what
terms,
did the judge say?
Okay, in layman's terms, for example, everyone has the right to freedom of expression. At the same time, in Canada, everyone has the right to vote if you're a citizen and you've been given the right to vote under our Constitution. However, what the judge is saying is that if you have so little time to implement this reorganization, that the voters themselves will feel that having gone from 47 wards to 25 wards, you're not giving voters the ability to express themselves in terms of representation, in terms of the type of representation they will have with a much, much smaller constituency. So that's what he's saying.
How unique is that argument?
It is a stretch, in my view, and that's why, again, I'm saying to the Premier, if you want this to go ahead, there's no need for the override clause. You can actually appeal this case. Maybe it'll be struck down. Take another time to reorganize the ward and go ahead with it. The judge has already said there's no problem with it. Even the Premier said there's no problem with it. But it's the time. By doing this in the middle of an election is where the judge has basically said there has to be stops.
The Ford government is saying, though, that they're facing a time crunch because they want to get this done prior to this election.
Well, why? And that's what the judge said, is where is the urgency to get this done immediately? I mean, if you had enough time, there would be no problem with this whatsoever. There would be no charter problems with this whatsoever. So,
was there an answer provided to that question?
In his view, no.
Is that the crickets?
That's the crickets.
Yeah, the judge wrote crickets on the decision,
crickets,
which was that a little bit? I read a lot of comments on Twitter. It was a little bit of an eyebrow raiser to a few profs.
All the lawyers across Canada tweeting, what the hell does this mean? And actually coming up with sounds. I gather the various media.
Our team as well put a little cricket sound in there, yeah. Right. And so, but basically, I mean, as funny as it is, he was saying that there are certain things that that weren't answered, essentially, in that respect.
Right. And again, he's saying, look, maybe with more time, the Premier could provide that evidence, and then there would be absolutely no problems with this. So my plea is basically to say, look, I mean, in the reality that we care about the Charter, we care about governments having the ability to implement their democratic promises. Go ahead and do it, but please, not in the middle of the election. Give them more time to do it.
I have less than 30 seconds left, but there was also some insinuation in the press conference that this decision could have been politically motivated, or there's something nebulous about this judge. What would you say to that?
Well, I personally know the judge, and I think that would be a terrible accusation, because he has been one of the most reputable judges in Ontario, and I would refute that completely.
Okay, I'll leave it there. Thanks a lot for your time, Professor Mendes. Great to see you again.
You're very welcome.